Where is the other side?
I'm informant में.
Somebody else was appearing. You will appear. You will address.
एक हैं योगेश शर्मा वर्मा सीनियर क्लर्क. वाहिद.
चलिए बहस करिए.
Making this the false statement before the court, it's
Yes. Now
only,
please try and understand what had happened.
Yes, Malad.
Now, before the order was dictated in open court, but
Yes.
before it could be signed, you made an application that the IA has not been disposed of.
Yes, Malad.
So we directed the order to be kept in abeyance till the time your interlocutory application. Therefore, the order has not been.
Yes, Malad.
So you you perhaps gave an impression, you never wanted to, but you gave an impression that the order has been signed, but it has not been uploaded. The order was directed not to be uploaded for the reason that we needed to dispose of the IA along with this.
Yes,
All right. Yes.
Malad, making this perjury before the court is not only affected, Malad.
That's right.
Not affected.
You show the
Yes, Malad, the statements where the statements been falsely the false statement have been made, Malad.
Yes.
If Malad kindly takes up the complaint, Malad, kindly takes up the complaint which I have been annexed in my bail application, Malad, as.
No. Tell us the statement made
Yes,
by
Yes,
the
Malad.
informant here in
Malad.
this court.
This the counter affidavit been filed before my lord by the respondent number 3, my lord.
Yes.
Which has been before my lord is. I'm taking my lord one by one, my lord.
Yes.
If my lord takes up the complaint which has been lodged before the economic offence being filed.
Show me from here.
My lord.
Complaint we'll see later.
My lord.
The complaint is not
the
before
statements,
this.
statements.
Complaint is
Yes,
not
ma'am.
before this court.
Yes, ma'am.
You are asking for
Yes, my lord.
initiation.
Yes, my lord. The affidavit.
From the counter affidavit.
Yes, my lord.
All.
My lord, Annexer B of the counter affidavit, my lord. Annexer B, page number 20. my lord.
This counter affidavit by Muhammad Kaisar Jamal.
Yes, my lord. May I read, my lord?
Just.
Internal page 10, my lord.
Yes.
Annexer B.
Yes.
प्रासंगिक आवेदन में, my lord,
Yes.
because I'm.
I will read it myself.
I can, प्रासंगिक आवेदन में मैं सूचक मोहम्मद केसर जमाल पिता मोहम्मद जहीर निवासी ग्राम पोस्ट सरमसपुर थाना महनार जिला वैशाली माननीय न्यायालय से निवेदन पूर्व कथन करता हूं कि जमानत आवेदक राकेश श्रीवास्तव ने अपने जमानत आवेदन के साथ 1-3 डेबिट वाउचर्स क्रमश दिनांक 7/9/2016 दिनांक 14/5/2017 एवं 12/11/2017 की तिथि का प्रति संकलन किया है, जिस पर राशि प्राप्त करता है रूप में मेरा हस्ताक्षर होना बताया है। श्रीमान को आग्रह पूर्वक सूचित करता है कि उक्त हस्ताक्षर मेरा नहीं है, मानद नहीं मेरा उक्त हस्ताक्षर किया है। राकेश श्रीवास्तव द्वारा मेरा हस्ताक्षर जाली बनाया गया है, जिसका सूचना मैं श्रीमान को दे रहा हूँ। मैं तथा मेरे संबंधी 5,16,000 रुपए सारदा प्लेजर एंड एडवेंचर के पास जमा कर चुका हूँ, जिसका रसीद मालक मेरे पास है। मालक रसीद किसके पास होता है? मालक नंबर 1 एजेंट के पास रसीद होते हैं। मैं और मेरे संबंधी यानी मालक केसर जमाल बिलोंग्स टू मुस्लिम मालक काइंडली सी द लिस्ट मालक देयर आर नंबर ऑफ हिंदू पीपल मालक हिंदूज आर देयर मालक राजकुमार मालक शर्मा इज देयर मालक Lakshmi Kumari was there, my lord. This Shobha Devi was there, my lord. All they are, my lord, the Sambandhi, my lord. In their complaint, what they have made.
Right.
Yes, my lord.
Kindly read that statement again for you to be satisfied at page 11.
My
The
lord.
third line, the second line from the top.
जिसकी मतलब रसीद मेरे पास है, then continuation वाला, जिसके मैंने अनुसंधान कर्ता को दिया हूँ, मैं और मेरे संबंधी ने
मैं और मेरे
मेरे-
संबंधी के अलावे,
हाँ।
ऐसा सुनिए ना आप, वो
बहुत
ग्राउंड में
लोगों का
के
पैसा
अलावे बहुत लोगों का
का
पैसा
पैसा
राकेश श्रीवास्तव गबन कर चुके हैं, जो करीब जो
जंदाहा
जंदाहा ब्रांच से ही
में
करोड़ों
करोड़ों
रुपया
रुपए-
गबन किया गया।
Yes,
उस-
my lord.
और भी बहुत लोगों की चर्चा है, नीड
Yes,
नॉट
my lord.
नेसेसरीली बी मोहम्मडन्स।
नो माय लॉर्ड, और जो बहुत लोगों की जो चर्चा है, ही इज नॉट स्पेसिफिक अबाउट अ व्हाट, जो बहुत लोगों की है। व्हाट इज कंप्लेंट माय लॉर्ड? मैंने करोड़ों लोगों का गबन किया है माय लॉर्ड, नॉट मेरा और बाकी संबंधियों का माय लॉर्ड।
340 का मैटर नहीं है ना।
माय लॉर्ड 340 का मैटर बन रहा है माय लॉर्ड। आई एम गोइंग टू शो माय लॉर्ड द नेक्स्ट द स्टेटमेंट बिफोर अस। मतलब ये तो लर्नेड लोअर कोर्ट बिलो में दिया हुआ द स्टेटमेंट्स है मतलब। इफ मतलब काइंडली टेक्स अप 164 स्टेटमेंट मतलब 164 स्टेटमेंट।
Ms. Mukherjee, we are not trying to cut you short. You have come from outside. We will give you all opportunity of argument.
मतलब
But see, what would I do with that 164 statement?
मतलब ये जो false जो statement ये जो दिए मतलब
That's
that is what I am going to point out before my lord is, अगर ये false statement अगर मतलब complaint is basis on the basis of false statement, एफिडेविट करके अगर ये झूठ बोलते हैं बिफोर द
That's
कोर्ट,
why this court is not going to initiate any action. No.
मतलब एफिडेविट विल फाइट बिफोर माय लॉर्ड इज बिफोर दिस कोर्ट माय लॉर्ड।
That's, you have read Marwa's case with respect
Yes,
to
yes,
340 and 195.
Yes, my
Check
lord.
it. Check the position of law again. This would not fall within 195 1B read with 340.
Yes, my lord. मैं
Absolutely.
आपको शो my lord.
We are absolutely clear in our mind, Ms. Mukherjee. You can.
My lord, there is my lord, H is very
You do one thing.
Yes, my
This is
lord.
an advisory from the bench. You keep this energy reserved. Now, once charge sheet is submitted against you, and you challenge the order of any court if the charge sheet is acted upon, and thereafter you could initiate this proceeding. But as of now, when I am only hearing the bail application and the order which I had dictated on the last occasion, which I have not signed for you to complete your arguments with respect to IA, which has been filed in this petition only, the only convenient answer for any lawyer would be that that is not the basis for the court to decide whether your application should be allowed or your application should be rejected. Now, in this case, it is no document which has been forged or any wrong statement having
Yes,
been
my lord.
made.
The false statement being made in 164, my lord. There are
164 is
contradiction.
not made before this court, no.
No, my lord, that was been affirmed before by way of filing counter affidavit, my lord. They have annexed.
That way, every case. You see, therefore, I have asked you to read Marwa's case. I don't remember the citation. It is of 1988. Ved Prakash Marwa versus so and so. Now, there you will find the logic of proscribing the powers of the court or the authority of a complainant or the other side of coming up with this accusation of furnishing false evidence. Otherwise, no suit and no criminal case and no writ proceeding would continue, and every statement which ultimately is not relied upon or found to be false would invite an action by way of complaint by the court. Now, if at all you find that these are wrong statements, you have various other options, but it will not stricto sensu fall under the offense of 195 1B or 192 193 of the IPC, 195 1B of the CRPC read with 340. This effort, Ms. Mukherjee, I must tell you, it is out of question. Take it, I mean, try and trust the bench. The position of law that I am telling you, you need to just check it up again. It's not done. Now, what I do is that I give you an observation that should you surrender before the court below, all these grounds shall be taken into account, and you shall, the order shall be passed without.
My lord, that inquiry should be made before, my lord.
That application you will have to file, not now. Keep it. That's why I'm not supposed to advise you, but I'm telling you because you seem to be quite passionate about this brief. Now, if you exhaust this remedy now, perhaps you will be left with no other course of action later. Now, let this case be investigated finally, let an order be passed, and then you get ample opportunities to challenge it. And then forget about the inquiry by the court or complaint at the instance of the court. Independently, for any false statement you can file a case. But if you impress upon the court for the court to file a complaint under 191, under 340, then perhaps you lose, and then you lose that forum also later, which you will get. Now, criminal cases are not argued and decided in such haste. Now, if you adopt this procedure now, you get an order today.
No, my lord, in 340 application, what I have prayed before my lord is, my lord, to direction may be given to the learned no court below.
No.
Made and,
Where is that? Now, read, you have not come in appeal, you have directly come here. Read 340.
Yes, ma'am.
CRPC. If the court below does not take an action on your complaint, on your petition, then you can come before the High Court for a direction. Have you went before the court? No. You are filing an application for initiating prosecution against opposite party number 3 on the sole ground that there are certain annexures in the counter affidavit which according to you is incorrect. If we allow this, then every case there would be an application for 340. It can't be done. Now look at 340 now. You come from a high court which is known for passing orders in the criminal side, but why do you have to sort of force the court to tell you? You know it better. Now look at 340 and then 341.
Yes, my lord.
An inquiry should be made into any offence referred to in clause B of section 1 of 195 which appears to have been committed in or in relation to proceeding. 195 1B talks of offences from 182 to 192 or 181 to 192 whatever, which appears to have been committed in or in relation to a proceeding in that court, right? So it is not in this court. Or as the case may be in respect of a document produced or given in evidence in a proceeding in that court, such court may after preliminary inquiry. So therefore this court, nothing has happened.
Counter affidavit been filed by
Counter affidavit is only that's right. This is a reiteration of this is no occasion for us to take it under section 340. Now therefore I said, please, even if I reject this petition, for learning sake, you read Marwa's case. That will keep you in good stead. Now come to 341 now. Or lest you should not have a feeling that you have not been heard, therefore I'm telling you all this. Otherwise I'm absolutely clear in my mind that it doesn't apply here. Now read 341 now. See, counsels from outside always have a feeling that they don't get good hearing in different high court. In order to dispel this, I'm giving you and I'm showing you all this provision, which is not required. 341.
Any person on whose application any court.
Therefore, have you appeared before that court? Have you made any application before that court? And is that court not taking up? But please, this is an advisory. Don't do that now. Do it sometimes later. All right. Look here. Heard MS Kumkum Mukherjee, learned advocate for the petitioner. And
Judge Mother,
yes.
when in Companies Act, Mother, if this is matter related to the affairs of the company, if my lord kindly takes up section 55, Mother, section 55, Mother, issue and redemption of preference share, Mother. No company limited per share shall after the commencement of this act issue and preference share which is irredeemable.
No, that's all right.
My lord, I can redeem my share.
We are not
20 years.
We are not non-suiting you on the ground that this accusation is correct or wrong, because you have not been able to appear before the court without any order.
My lord, as and when this
we have said that we will that day I have dictated the order.
Yes, my lord.
I will only add
I was not shown any absconding, my lord. In my lord, done it court below, what they have done, they have, my lord, after, my lord, the complaint being filed on 2014, my lord, November 2014. Thereafter, my lord, FIR was been taken up after 318 days, my lord. There was a delay, my lord. Then thereafter, my lord, the court, learned court below was taken up this matter after 918 days, my lord. But there was already 4 years already been gone.
All right, please don't go into all those details. I have given you a very
straight away after 164.
I have given you a very safe passage. And I have also given you the observation, which you will find it very handy when you surrender before the court below. I have said that if you go before the court below and say and demonstrate that 80% of all such dues has already been paid up till now, and therefore your intention is clear, not to dupe the investors, but it's just a case of sagging financial viability of your company, that shall be taken into account by the court and then an order shall be passed. I couldn't have been more indulgent, MS Mukherjee, right? So this is what we do. Usi order pale upar mein likho. Heard MS. No, then I issue notice.
I'm sorry.
Then I issue notice, Mr.
I'm withdrawing.
Now you came midway. Huh? I would have otherwise please take this is just in lighter vein. You are a senior advocate. You cannot remain tied to one court. You have to go before other courts. But please wait here now. Look here. This matter was heard on several dates. What was that date when this order was dictated?
20th January.
21st.
Are you sure?
Is January.
Check up the records. This matter was heard